All right.
Good morning.
Morning.
My name is Denise Heekin. I'm an attorney with the law firm of Bryant Miller Olive. I am board certified in labor and employment law by the Florida Bar. One of my partners, Mr. Jim Crosland, was supposed to be here today to give you this presentation, but unfortunately he had a family illness. So hopefully you will see him at some point in the future. Okay, where are we? On August 22nd, 2016, the United Faculty of Florida filed a representation certification petition to represent a bargaining unit consisting of full-time faculty, counselors, and librarians. The petition itself excludes the president, assistants to the president, registrars, directors, deans, basically your administrative, professional type people. On August 26th, PERC issued the notice of sufficiency. PERC is the Public Employees Relations Commission, and that's the agency with the state of Florida that regulates labor relations for public employers and public employees. So we need to file a response by September 22nd, 2016. Basically, our response will state whether we agree or disagree with the unit proposed by the union. Currently, we're assessing whether or not librarians and counselors are appropriate for inclusion in that unit. So what happens? Once we file our response, if there's a disagreement over the bargaining unit, there'll be a hearing in front of a PERC hearing officer. And this is an evidentiary hearing. And basically, we'll put on evidence as to why the positions should not be included in the unit if we decide that there are certain ones that we don't think are appropriate. After the hearing, each party gets to file a proposed findings of fact and conclusions of law. We have 15 days to do that. The PERC hearing officer will issue a recommended order within 30 days. Each party can file exceptions to the hearing officer's findings of fact and conclusions of law. We have 15 days to do that. Each party then can file exceptions to the other party's objections, which is 10 days. And then finally, PERC will issue a final order. So all said, if we don't agree on the bargaining unit, we're looking at least 70 days before there's any type of election. If the parties do agree on the appropriate bargaining unit, then the parties will move forward with a consent election agreement. And essentially, I mean, at that point, you can probably have an election within a month. So after there's a determination on the appropriateness of a bargaining unit, PERC will schedule an election. And there's two different ways they do this. They can either do a mail-in ballot or they can do an on-site election. Really, the parties kind of negotiate that between themselves, and then they go to PERC, and PERC will try to do what they can to adhere to the parties' wishes. If there's a disagreement, then really it's just up to PERC to decide whether it'll be a mail-in or an on-site election. An election is a secret ballot process, so every faculty member can go ahead and put in a vote, and it's secret. During this process between really now and when there's an election, there's going to be some campaigning going on. You're going to hear some information from the college, and we're going to encourage you to put that information out there because you want to have educated voters. You want them to know what it means to have a union, what a union can do and what a union can't do. There's also going to be campaigning from the union, and they're going to put information out there saying all kinds of things about what unions can do for those employees. You might also have some other groups of employees who are not for the union, and they may be putting some information out there themselves. And really, you want to encourage a dialogue, you know, to have objective information out there and make sure that everybody is an educated voter. You know, after the voting process, there is another period where there could be challenges. Unfair labor practices would just extend the period of time by which an actual bargaining unit would be certified by the agency. There's 3 basic rules during this campaign period. First of all, you can't discriminate against employees because of their union sympathies or their union activities. Secondly, you cannot make threats or promises in order to discourage union activities or sympathies. So you can't say, hey, if you don't vote the union in, we're going to give you a 5% pay raise. That would be a promise. You can't do that. And the same thing with making threats. Thirdly, you cannot interrogate employees about their union activities or sentiments. So for example, you don't want to ask employees whether they signed a union card, whether they attended union meetings, how they feel about unions or how they feel about UFF, or how they vote in election. You also can't spy on them. So that means the administration isn't going to send people into union meetings to spy and listen to, what's going on and come back to report. We're going to have an open dialogue about this. First of all, the college has a legal right to engage in free, non-coercive speech and conduct when a union is attempting to organize employees. So you can, and you should, express your position on unions. So if any of you have any prior experience with a unionized workforce, you're certainly entitled to and are free to share those experiences. You should talk to employees and enlist employee support for the college's position through direct contact with and conversation with those employees. So permissible talking points. You can state that you and the college are opposed to the unionization of employees. You can state why you think it's unnecessary for employees to have a union here at the college. And you can point out that while the union might make all these promises about what they can do, there's a difference between promises and guarantees. We're going to go through this a little more later, but a union cannot make the college do anything that it does not agree to do. And that's an important point. You want to emphasize with the employees' financial obligations, because if they decide to join the union, there's initiation fees, there's dues, there could be assessments, fines, and that's what happens when employees join a union. You want to answer and refute as fully and factually as possible any false statements or misleading assertions by the union. So throughout this period, if there's campaign materials that are put out there that may not be completely accurate, the college can and should address that and provide the employees with the correct information. You want to also emphasize during this period that the wage rates, and my understanding is St. Pete College is very high up there in wage rates in comparison to the other community colleges and colleges throughout the state, and our benefit programs. That those have all been provided by the college without a union. And those are all things that the employees have now, and they didn't need a union to get it. So, to reiterate, you can and you should express your opinion. You can listen. You can encourage questions. You can lend a sympathetic ear, and you can inquire as to how things are going on the job. Those are all perfectly fine topics of discussion. Now, employee questions. A lot of employees are typically not aware of their rights or the employer's rights and obligations when it comes to unions. We want to make sure that we answer all of the employee questions truthfully and correctly, and this is important. This is what they should know. Employees do not have to sign a union card. They don't have to speak to union organizers. They don't have to belong to the union. Florida is a right-to-work state, which means by law, they cannot be forced to be in a union. They can't be required to join a union to keep their job. Now, if they choose to belong to the union, they'll have to pay dues. And the dues for UFF currently is 1% of whatever their regular salary is. That's a lot. Also, employees should know that they can vote against the union, even if they signed a union card. The election is their opportunity to vote freely and secretly, and they can vote against the union if they choose to. Moreover, they can vote against the union even if they're a member of UFF. There are a lot of faculty that are members of UFF because they get some benefits from that, insurance stuff, but they don't have to be in a bargaining unit. And there's a lot of faculty that are members of the UFF that are not in a bargaining unit. one thing is that employees really have to understand how important it is to vote. We want them to be educated, we want them to be fully informed, but they have to vote. The union does not have to get a majority of the people in the proposed bargaining unit or in the bargaining unit. It's just a majority of those people who vote. So if a bargaining unit includes 300 faculty members, but only 150 of those people vote, it's 50% plus 1, so 76 people. 76 people could vote in the union, and that union is going to be responsible for representing all 300 individuals. So it's very important that they vote. When employees don't vote, it's like they're casting a ballot for the union. Again, another thing that's important for them to realize is that they can't just try on a union. Once a union's certified as a bargaining representative, it's hard to get rid of a union. You know, employees should understand that you just can't try them out for a little while. At the very least, if a bargaining unit's certified, they're here for at least a year before a decertification petition can be filed. And it's a lot more difficult to get rid of a union than it is to vote them in. So they need to understand that. So let's talk about bargaining. Bargaining unit, let's say they vote for the union. Bargaining is important. There's some true and falsehoods that really need to be understood. A lot of times you'll hear during the campaign process that, hey, once we get in, we'll automatically be able to get you a pay raise. You know, we will automatically get you all that we're promising during the bargaining. But this is false. A union cannot guarantee certain benefits and wages. A union cannot guarantee that the college will even sign a contract. The union cannot guarantee job security. The bottom line is the union cannot force the college to provide anything the college does not want to provide. Our responsibility is that we're required to engage in good faith bargaining. Good faith bargaining means that we meet at reasonable intervals, reasonable times. That's what it means. It does not require us to agree to anything. So the college does not have to agree to any type of language in a collective bargaining agreement that the college does not think is in its best interest. The union cannot guarantee any new benefits in bargaining. And in fact, they can't even guarantee that employees will receive the same benefits that they receive now. Because the bottom line is everything's on the table. So negotiations could result in some benefits staying the same. It could result in some benefits increasing, and it could result in some benefits decreasing, because everything's out there to talk about and negotiate. The important point is that the union has no power to legally or otherwise tell the college how to operate. Now, if a union's elected, the college's hands are tied as to who it can deal with for negotiations. The college can only deal with the certified bargaining representative. So the college can't deal with the faculty senate any longer on wages, hours, or terms or conditions of employment. That's up to the certified bargaining representative then at that point. Also, the college cannot deal directly with individuals or other employee representatives on wages, hours, and terms and conditions of employment. The bottom line is, little bug. The bottom line is it will all go through the bargaining agent. So, subjects of bargaining. An employer only has to bargain about items that are mandatory subjects of bargaining. So that's basically wages, hours, and terms and conditions of employment. There are some things that the college has managerial prerogative on, which means we can make the changes to it. We might have to bargain the impact of those changes, but we have the absolute right to make the decision on these managerial subjects of bargaining. The mandatory subject of bargaining, and this is just a list, it's not all inclusive, just wages, benefits, teaching loads, office hours, attendance at graduation, sabbatical, faculty senate, evaluations, a grievance procedure. Those are all things that will be talked about at a bargaining table. Okay, permissive subjects of bargaining, or these are issues on which we have a managerial prerogative. Those subjects include layoffs, subcontracting, academic term, the type of academic programs we offer, class size. The college has absolute right to make a decision as to these types of issues. And then, like I said, you might have to bargain the impact if in fact there is an impact of that decision. But the union can't dictate how we will operate on those issues. And in fact, Florida statutes contains a definition of managerial rights. And that's at section 447.209, which is really up on the screen. The statute says, it is the right of the public employer to determine unilaterally the purpose of each of its constituent agencies, set standards of service to be offered to the public, and exercise control and discretion over its organization and operations. It is also the right of the public employer to direct its employees, to take disciplinary action for proper cause, and to relieve its employees from duty because of lack of work or for other legitimate reasons. Okay, impasse. And this really shows you how the college ultimately has control of working conditions. You know, despite the parties' good faith attempts to negotiate a collective bargaining agreement, and you know, if a bargaining unit is voted in, college is going to bargain in good faith. But there are a lot of times when the employer and the employee organization cannot agree. So in that case, one or both parties declare an impasse. And so you go to PERC. PERC will be asked to provide a list of special magistrates. Special magistrate will have a hearing on all the issues that are at impasse. Each party will present its side, and the special magistrate will go ahead and issue a recommendation. The recommendation will be issued to the Board of Trustees. So for the college, the legislative body is the Board of Trustees. The Board of Trustees will review those recommendations, and they will make a decision on the outcome of those issues. You don't have to follow the recommendation. You're free to modify it. You're free to follow it. You're free to reject it. Any recommendation from the special magistrate, it's ultimately up to you guys to decide what the working conditions will be. And so after you consider the recommendations from the special magistrate, you, as the Board of Trustees, will impose the working conditions on all of those issues that went to impasse. So, why oppose a union? We don't think a union is necessary or beneficial to the best interests of the college's operations, the faculty, or the rest of the college community. We don't think a union will represent the best interests of all of the faculty, counselors, or librarians. We think that the college will operate more productively and efficiently without a union. A union is going to affect the college's ability to work with bargaining unit members on an individual basis to resolve issues. And frankly, collective bargaining takes time. Any questions?
How you know, with my background, worked with the IBEW a lot, probably about 30 years, and the whole system of seniority and kind of how you hire and terminate and those kind of things. How does that enter into the kind of the college system with tenure and those type things? They seem to be a little in conflict possibly with how those type things would take place if there was a union.
Well, it's subject to collective bargaining. Now, the Florida statutes and the Florida Administrative Code provide some law in terms of what's allowed in Florida. And continuing contract are one of the things that's discussed there. But that doesn't mean that you couldn't negotiate continuing contract away. You may be able to do that. So in terms of I'm not really sure there's a conflict. It's all on the table for purposes of bargaining.
Okay. Any other questions?
Well, I guess strategy going forward, I guess what is the strategy going forward is my thought. I mean, I've had a lot of interaction with PBA, FOP, FIAA, or IFAA, SEIU, presided over impasse hearings. Unions serve a purpose, I get that. I also think that this is kind of a push by a minority of employees to address random phantom issues and some random labor practices. I personally support their right to exist, but would oppose the vote if I had a vote, which I don't. As this is almost one of those be careful what you wish for scenarios. As a collective bargaining unit, the grass is not greener. It's not status quo is not guaranteed. Benefits can be reduced. Plus, I don't even think salary and benefits is what's driving this. Can't be. So, what is? I guess we have to decide do we oppose it? I know we can, we do have our right to free speech. There was that area in here where we could go in front of PERC and argue who's a member of the bargaining unit, and I don't know, I mean, that's almost one of those, do we fight it? Do we care? Anyway, let's discuss.
Yeah.
Discuss amongst yourselves.
Mr. Chairman, may I?
Sure.
Mr. Foster, we've been in contact, obviously, with our attorneys. First and foremost is determination who's in the bargaining unit, okay? We made some very deep-seated changes here at the college, certainly since I got here in 2010, to change the contract status and the way librarians and counselors are identified, hired, compensated, all of that. We have asked the attorneys to contest. We don't think those are mutual interests with the classroom faculty. We think they're the ones who should have the right to vote. So step one is for us to say we don't believe librarians and counselors should be in the bargaining unit. And that it's a very complex issue. Even though we changed their contract status and other things, they look behind it. What do they do every day? Who's responsible to students? Who does different things? It's not at all as straightforward as we had thought it would be. So that is being worked on as we speak, is to first of all say we don't believe those folks should be in the bargaining unit. We'll wait to get the response from PERC on that and make a decision going forward. I think after today, and we see then what it's 70 days. It may not last all of 70 days. It could take longer. I think the next step is for me to make appointments on the campuses and meet with faculty as a group and say, here is what we see happening with this initiative. Let me make sure you have all the information, just as was pointed out here, because quite frankly, I think one of the things Denise would tell you is that they've been to this dance. They know what the dialogue sounds like in a faculty member's office. They know what the promises or the implied promises are, and how robust, that this is going to be Christmas morning every day. We need to say, here's what it can look like on the other hand. The board has the final say in the way things work. We want to make sure everybody has all the information. We ought to hear from our faculty as to what it is that's driving it, if they have questions about what happens next. And then, be available to answer questions. There's a good number of our faculty, to be perfectly honest, who are already working to say, we don't want to do this. And it's starting to create a considerable rift in the faculty. The union folks are quite aggressive when somebody raises their hand and says, this is not what we want. They tend to fire pretty hard at those individuals. So I think our next goal is, after having met with the board, having met with our attorneys, is to go out and say, here's what bargaining can look like when all is said and done. And you know, we will certainly act within the guidelines. We'll certainly be as straightforward as we can. My goal is to be sure that nobody, that everybody who is eligible to vote has a full range of information on what a vote can look like. And then people can vote however they deem best.
Go ahead.
I did the math. So for a $50,000 a year employee, that's $500 a year in union dues. That's $500 a month, $500 a year for someone to lose their right to individually represent themselves. And that's a $50,000 middle of the, you know, middle of the road employee. My position would be, is that person who really doesn't want to get involved, doesn't want to really raise their head, and doesn't want to really take the hit, doesn't want to have to deal with it. I would like to see us actively encourage people to vote. Actively encourage people to vote. Whichever way it comes out, the chips fall where they may. But personally, I would like us to represent that person who's about to lose we just struggled over $10 a month raising health insurance fees. $10 a month, and we sat up here and talked about it for 20 minutes. I would be remiss as a trustee if I didn't sit there and say, hey, I'm about to yank $500 out of somebody's pocket a year. I would ask that we certainly make sure that all the correct information is out there, but at the same time, you know, in a way, be the voice of the person who really just wants to go to work, teach students, go home, pick up their kid at daycare, and just be done with it at the end of the day.
One thing that I want to mention, if a union is voted in, an employee does not have to automatically join, but the way in which they may be treated by the union could be very different depending upon the bylaws. So for instance, I know I have some bargaining units, if you're not a member of the union, they don't have to represent you in a grievance procedure. So.
Who can be on the bargaining team? Who can be on the executive committee? I mean, there are any number of stratifications as to whether or not you pay dues and what you can then do as a member of the bargaining unit. So all of those are up for grabs.
But you're absolutely right. In order to be a full functioning, the dues are a lot of money.
Mr. President, I don't know if you're looking for a vote, if you're looking for direction. I think you've heard at least some of us chat about what our thoughts are. How do you want us to proceed? What are you looking for?
I think what I need to do is to indicate to you that I'm going to proceed with scheduling campus-based meetings. I would expect that by this time next month, some of those will already have taken place. I intend to have as many as the faculty are interested in doing. We should, I guess, schedule monthly updates so that you hear from us what we think is happening. You'll hear it from others, I can guarantee you. And then be available to you in any way. But I suspect that here's what I'm taking away. The college believes very strongly that we have treated everybody very dutifully. I think this board has been incredibly supportive of instruction and faculty members. I think you've done a great job. If people have a grievance, they need to evidence that. But once again, I meet every month with the FGO. These are not unresolved issues that we've deflected on for months and months and months, or years and years and years. So I will take the guidance from the board today to proceed apace and to make sure that everybody has a chance to be heard.
Dr. Law, would it be beneficial at all, or even allowed, I'm not sure if it is, for some representatives from the Board of Trustees to attend any of those meetings with you?
I'd be happy to have, why don't we get, when we get a schedule, if you
Why
want
don't
to
we
be
do
there
that?
that day,
Sure.
that would be very helpful to have you in attendance to hear it and to answer. It's a good suggestion.
Okay.
Good idea.
Any other comments?
Okay,
Mr.
thank you.
President, you have your kind of,
We'll schedule this as a regular item for the next few months till it's clearer as to what's going to happen when.
Okay. All right, any other questions to Denise?
Thank you.
Appreciate it.
All right, so we'll
Thank you.
close the workshop.
Good.
Meeting's adjourned.
Thank you.
What time is the call-in?
Noon.